Okay, so good afternoon, everybody. My name is Roselle Kim. I use she, her pronouns. I'm a senior staff lawyer at the Women's Legal Education Action Fund, LEAF for short. Thank you so much, everyone, for joining us today. I see there are over 200 of you, which is great. Our panel is called Bridging Justices, a discussion about restorative and transformative justice for sexual harm. We're so grateful that so many of you have decided to spend your afternoon with us exploring non-carceral justice options for survivors of sexual harm. This panel will discuss the new report, Bridging Justices, a critical exploration of moratoriums and restorative and transformative justice for sexual harm in Ontario, which was released on November 27th. The report was a collaboration between LEAF and Community Justice Initiative, and written by Drs. Mandy Gray and Jessica Evans, whom I will introduce later on. This project was funded by the SSHRC Partnership Engage Grant and the McConnell Foundation. We are grateful for their support. So before we get started, I just wanted to share some housekeeping matters and tools for participation. This panel will be in English. We do have French interpretation available. To listen to the panel in French, on the bottom row of Zoom, you will see a button that says interpretation, and then you can choose the French channel to listen to the panel in French. We have some time to answer questions from the audience as well in the end, so please submit your questions. There is a Q&A option. I think if it's not showing up for you right now, if you click on the three dots at the bottom right of your Zoom, there should be an option for Q&A. If you're experiencing any technical difficulties, please reach out to me or my colleague Celia, and we will try our best to help you. And if you're a legal professional in Ontario, this panel has been accredited for 1 EDI professionalism hour and 30 professionalism minutes. We have an hour and 30 minutes today, and this panel will conclude at 6 p.m. Eastern Time. I will provide a roadmap of our time together. So I'm going to provide some brief introductory remarks discussing the context that led us to this work. Next, the report authors, Drs. Mandy Gray and Jessica Evans, will discuss the report, including the policy recommendations from it. Then we will have a panel discussion with our panelists, Audrey Huntley, Laura Morrison, Robin Parker, and Rakesh Walters, which will be moderated by Kate Crozier. At the end, we'll take questions from the audience. As I said, you can submit your questions throughout the panel by using the Q&A function. So what brings us to this place of exploring non-carceral options for survivors of sexual harm? I want to first situate our discussion by acknowledging that I'm joining you from what is now known as Toronto, the traditional lands of the Mississaugas of the Credit, the Wendat, and other Anishinaabe and Haudenosaunee nations. This land is governed by the Dish with One Spoon, Wampum Belt Covenant, a nation-to-nation peace agreement between the Anishinaabe, Haudenosaunee, and other allied nations. In acknowledging the land we're on, we must also reckon with the violence of colonial systems that disregarded agreements like the Dish with One Spoon Covenant, instead imposing a set of rules and systems without Indigenous peoples' consent. And we are continuing to live within these systems and rules that started out as a violation. I mention this because it's important in our discussion about restorative and transformative justice. We can, and we must, imagine a better way of justice, one that centers the most marginalized, and one that operates based on consent, not imposition. As a legal organization with a focus on substantive gender equality, LEAF has intervened in almost every major sexual assault case before the Supreme Court of Canada to advocate for the rights of survivors, including their right to dignity and privacy. We have also intervened in court cases to exclude harmful myths and stereotypes about survivors from the criminal trial process. Along with the work of survivors and advocates, Our advocacy has led to positive change in sexual assault laws on paper. Yet survivors continue to report how the criminal justice system is not working for them and further re-traumatizes them. By and large, the criminal process is not a trauma-informed one, though there have been small steps along the way to address it, to change them. Survivors are often subjected to invasive lines of questioning. In addition, the criminal process is also a lengthy one that can take years. We cannot achieve justice without centering survivors, yet the system fails to do so in many ways. Survivors do not have control over the criminal process because they are not a direct party, but a witness. It is the state that brings a charge against the accused person. The lack of agency and control is another source of re-traumatization. It is also important to acknowledge that survivors are not a monolith. They come from different backgrounds and histories. They may be facing different and multiple systemic barriers, including being criminalized themselves. For example, if you're Black, Indigenous, or racialized, or if you're a sex worker. Survivors also have different relationships with the people that harm them. All of these factors lead to the reality of survivors continuing to be harmed by the criminal legal system. According to a recent Statistics Canada report, 6% of all sexual assaults were reported to police. So what do we do next? The solution has to start with asking what the survivors need and want, and ensuring that they can be full participants in the processes that work for them, and in systems that remove structural barriers. This is where our exploration of restorative and transformative justice comes in. I will now introduce Drs. Mandy Gray and Jessica Evans, authors of the Bridging Justices report. Dr. Mandy Gray is an assistant professor of criminology at Trent University. She has been involved in anti-violence activism since 2008. Her debut book, Suing for Silence, Sexual Violence and Defamation Law, critically examines the growing trend of men accused of sexual violence suing their accusers. She is the co-author of LEAF's 2023 report, Avenues to Justice, Restorative and Transformative Justice for Sexual Violence. Dr. Jessica Evans is an assistant professor in the Department of Criminology at Toronto Metropolitan University. Her community-engaged research examines the causes, conditions, and consequences of incarceration in Canada, framed through anti-racist, decolonial, abolitionist, and critical political economic theories. Thank you, Dr. Gray and Evans.
Thank you, and I apologize. I'm going to be sharing my screen now, so just give me a minute while we figure out tech once more, as we're going to do a brief slideshow of the findings of the report. So, thumbs up if you can see my slides okay. All right, amazing. I'm Mandy Gray, and I co-authored this report with Jessica Evans. And the background for the report really stemmed from the initial report that I wrote with LEAF that Roselle mentioned, that was Avenues to Justice. Maybe we could put that in the chat for folks if they want to check that out, because that really laid the groundwork for this report, which led me to meet Kate, who you'll be hearing from in a moment, who is interested in looking specifically at the policies around access to restorative justice through alternative measures under Section 717 of the Criminal Code, and more specifically looking at whether there was support within the gender-based violence sector more broadly to look at and expand the options and availability of non-carceral options to respond to sexual harm. So this most recent report is called Bridging Justices, a critical exploration of moratoriums on restorative and transformative justice for sexual harm in Ontario. And while the report was focusing specifically on Ontario, it's been really neat to see interest in our findings across Canada. To give you a bit of an overview, we figured that not everyone would be have a background or knowledge about what restorative and transformative justice refers to. So I'm just going to give a very high level introduction to what we're talking about when we talk about restorative and transformative justice. And of course, the panelists will also bring in their own definitions and caveats into this definition. So it's really critical to acknowledge that there are distinct histories and political foundations for restorative and transformative justice, but there's really an overlapping foundation that they're non-punitive, non-adversarial, and their philosophy is rooted in repair, healing, and relationships. It's really intended to respond to the needs of all the parties involved to address the harm, from the person who caused harm, the person who was harmed, as well as the broader community. Of course, there are many Indigenous legal traditions across Turtle Island that are also rooted in similar principles. Again, something we're going to be talking about a bit more on the panel discussion. And it's really critical to note that all these different systems of approaching justice have different relationships to the formal legal system and the state more generally. For the purposes of our report, we looked very narrowly at restorative justice because of its ability to fit within the current criminal legal system. And that is just one caveat of this current report, there was a big focus specifically on restorative justice as opposed to Indigenous legal traditions or transformative justice that may have differing relationships to the criminal legal system and the state. Section 717 of the Criminal Code does allow for diversion to what they call alternative measures, but Ontario Crown Policy D4 prohibits the use of Section 717 for sexual offenses, which means it makes it really challenging for Crowns, or near impossible for Crowns to divert cases under Section 717, even if that is at the request of the survivor. And we've heard from a few survivors in Ontario who have spoken out and have had significant difficulties in accessing restorative justice once charges were laid. And that was really the crux of what this research project was, to look at whether there was support to amend this Crown policy, and specifically what support was for the overarching use of restorative or transformative justice, but really focusing on the restorative justice because that could fit more nicely into the Crown policy. The research questions guiding this project was, as I mentioned, the primary question being, what are the main perspectives among subject matter experts regarding the Crown Policy D4 that prohibits the use of restorative and transformative justice for sexual offenses? Secondary research questions included, if the moratoriums are removed or revised, what steps would need to be taken by provincial governments to ensure concerns around survivor safety are addressed? What capacities and resources would organizations need to ensure the success of delivering restorative and transformative justice options for sexual assault? We relied on mixed methods approach. We did a survey that was distributed, and we had a sample of 155 respondents. We did semi-structured interviews with people who worked in the gender-based violence sector. Their roles were quite diverse, included people working in healthcare, for example, nurse practitioners and nurses who did the sexual assault nurse examiner kit. We talked to lawyers. We talked to people working in shelters, people working in management within gender-based violence organizations. We also did focus groups. Majority of the focus groups were online, but we did do one in-person focus group at a women's shelter. And then we held a community gathering to report back to community on our overarching findings and get some feedback on the recommendations that we had prepared from this preliminary analysis. We had some troubles in recruiting in Northern Ontario, which was a major limitation for us, and hope that future research can fill this gap. I also forgot to mention our research was funded by SSHRC and the McConnell Foundation, so we're greatly appreciative of that support to do this research. I'm going to pass it over to my colleague, Dr. Evans, to go through the recommendations from the report.
Great. Hi, folks. Thanks so much for joining. And Mandy, thank you. So these are the kind of key recommendations that we came to. And again, these recommendations were generated kind of in conversation with community. So the community event that we held in May, we kind of tabled some of our initial thoughts on what recommendations could look like. And then we kind of asked all attendees, I think we had about 50 to 60 attendees, to kind of comment and to provide feedback on those recommendations. And so the recommendations we lay out in the final report reflect that. I want to flag that in general, when we were doing the survey, and we don't have time to go over all of that data right here, but overall, we found that 85% of folks that responded to the survey said that they would consider themselves generally supportive of expanding RJ and TJ options for gender-based violence and sexual harm. And about 75% of respondents indicated that they would refer people to RJ, TJ options if they were available to the community, and if those services had the requisite experience. And so, given the kind of overwhelming support there's been for kind of addressing this and removing the Crown policy, our recommendations are as follows. So first, number one, and the key kind of answer to the question that we posed, or that kind of solid first question, was that we recommend that Crown Policy D4 be amended to allow for diversion under Section 717 of the Criminal Code. We're also recommending that when this does happen, if this does happen, that such diversions should be survivor-led and initiated. This again is in response to, and there are clearly some complexities in this, but this is in response to concerns that kind of were prevalent when this policy got put into place in the first place, which is that, you know, those who have potentially committed harm or caused harm might use this as a quote unquote easy way out. There's a lot to break down and contest with that sentiment, but nonetheless, we felt that indicating that this should be survivor-led and initiated might help to mitigate some of those concerns, which were repeated in our interviews as well, concerns that defense counsel would use RJ and for kind of unjust reasons. And so that's our first kind of primary recommendation. The second is that there is a need to provide public education on non-criminal legal options for sexual harm. Again, what we heard throughout these interviews were that people didn't know, or the people that they were working with did not know that restorative justice was even an option. And when they did know about restorative justice, oftentimes it was kind of high-level theoretical engagement with restorative justice rather than understanding what it looks like in practice. And so for survivors to know that they have this option and to know what this option could look like requires considerable work in terms of public education as well. And so that is our second recommendation. Third, we recommend that the province conduct a province-wide community consultation on restorative and transformative justice implementation. Here, once again, the goal is to have significant input from community so that when these things are happening, they are reflecting diverse cultural, religious, and various other kinds of needs within the community. The fourth recommendation is to fund and launch a restorative justice or transformative justice pilot sites for sexual harm. These must be community-led. They must meet the diverse needs of the community. And we're recommending that these be run for 3 years. Once again, if you look at our final report, you will see that we have, and actually this is the work of my wonderful colleague, Kate Crozier, but she has kind of prepared a template budget of what this 3-year funded pilot project could look like and how much it would cost, and the breakdown of those expenses as well. Fifth, we recommend supporting Indigenous sovereignty and legal revitalization. And then fifth, we recommend providing sustainable provincial funding for RJ-TJ education and capacity building. And so I don't want to take up too much time here. I'm going to leave it at that. And thank you folks for joining us.
Thank you so much, Dr. Gray and Dr. Evans. Now I would like to introduce Kate Crozier, who's the Interim Executive Director of Community Justice Initiatives, our partner organization for this project, and she will be moderating the discussion. Prior to working at Community Justice Initiative, Kate spent most of her career working with women impacted by violence. Along the way, she had the opportunity to work with criminalized youth, unhoused women, and men impacted by sexual harm, which helped her understand how people who fall through the cracks often become criminalized. She has spent 20 years working to address the impacts of gender-based violence through a mix of feminist anti-violence work and restorative justice work. Both of these fields of work have led her have fed her interest in tackling both personal and systemic issues through non-carceral pathways. For her, one of the best parts about working within a restorative justice framework is the ability to work with people who value meaningful accountability, community building, and radical inclusion. So I'll pass it over to Kate, who will introduce the panelists.
Thanks, Roselle. Yeah, it's my pleasure to introduce this phenomenal panel today, and I will start with Audrey Huntley. Audrey is of European settler and Indigenous ancestry. She grew up an army brat between Calgary, Alberta, and Germany. As a young adult, she lived in Europe for 16 years. She studied, worked, and became part of an anti-authoritarian social movements fighting racism, fascism, and gender-based violence in Germany, France, and Italy, before returning to Turtle Island in 1998, and has been involved in anti-colonial struggles in British Columbia and Ontario ever since. Audrey is a licensed paralegal who works with survivors of violence at Aboriginal Legal Services, a filmmaker, storyteller, and the co-founder of No More Silence, working with other Indigenous women, trans, and Two-Spirit people to end gender-based violence and colonization. Recently, the group opened their newly created Hummingbird Healing Lodge, providing accessible ceremony and therapeutic wellness at 6 nations of the Grand River. Laura Morrison is with us today, and Laura is a survivor, advocate, and researcher whose work focuses on building survivor-led, transformative justice alternatives to the criminal legal system. Grounded in decolonial and anti-oppressive frameworks, she examines how communities can respond to harm in ways that disrupt white supremacy, center healing, and build collective safety. Laura's work bridges lived experience, research, and advocacy to reimagine what justice can look like beyond punishment. Laura works as a member of Survivors for Justice Reform and is a PhD candidate at York University. We're also welcoming Robin Parker to the panel. Robin practices criminal and human rights laws and investigates human rights issues for institutions with a focus on sexual violence. Robin has seen all sides of the courtroom, prosecuting and defending cases, and representing witnesses in Ontario, Nunavut, and the Northwest Territories. She has testified before the Justice Committee on victims' issues and assisted with complaints across the country. In 2024, she was awarded the Victim Services Award of Distinction by the Attorney General of Ontario. In 2008, Robin received an Award of Distinction from Oxford University for her master's studies in international human rights law. She is a certified workplace investigator in the University of Toronto and is trained in a trauma-informed approach by the National Institute for the Clinical Application of Behavioral Medicine and the Crisis and Trauma Resource Institute. She is pursuing a certificate in conflict management and mediation at Conrad Grebel College with a focus on restorative justice practices, and has received her transformative mediation certification. She sits on the Restorative Justice Advisory Circle of Ottawa's Collaborative Justice Program. And finally, I'd like to welcome Rakesh Walters, who is a Canadian lawyer and doctoral candidate at Berkeley School of Law. She is also the Stuart DCL Research Fellow at Queen's University Faculty of Law and a Research Fellow at Harvard's Law School Institute to End Mass Incarceration. Rakesh's scholarship concerns the constitutive power of race in criminal legal institutions. Rakesh completed her Master's of Law at Columbia University as a Fulbright Scholar and a Davis Polk Fellow with high honors. She also completed her JD cum laude at the University of Ottawa. She served as a law clerk to the Justice Sheila Martin at the Supreme Court of Canada. Rakesh is called to the Bar of Ontario, Canada. Before graduate school, she practiced as a criminal defense lawyer at a top criminal law firm in Ontario, Toronto, Ontario. She appeared before all levels of court, including before the Supreme Court of Canada. As you can see, this is a pretty all-star panel here, and we have a few questions we're going to pose. And while each panelist has a lot to contribute to each question, I'm going to invite just a couple of panelists to respond to each one to honor the time that we have for today. Our first question: the current Crown policy effectively denies survivors the choice of restorative justice in cases of sexual harm. From your perspective as survivors, researchers, and advocates, what are the consequences of this restriction? And what would a more just policy framework look like? Laura and Robin, I'll invite you to respond.
Thank you. Thank you for the question. And I'm very happy to be here to speak about these things. The consequences of the D4 policy restriction are profound, and they are profound in a very harmful way. Firstly, D4 removes decision-making power from people who are most directly affected in the situation. Sexual violence already involves a loss of agency, and many of us spend years trying to reclaim even the smallest sense of control over our lives. So when a survivor explicitly asks for restorative justice and is told categorically, you are not allowed to do that, the message we receive is painfully familiar, which is that you don't get to decide what happens to you. It's deeply paternalistic. And this restriction exists in a context where very few survivors ever see meaningful outcomes in the criminal justice system. As was mentioned before, Statistics Canada data shows that only about 6% of sexual assaults are even reported to the police. Most survivors do not report because they have a fear of not being believed. They do not trust the system. They worry about stigma. And a lot of that is because they know that the process is re-traumatizing and that the process rarely gets them anywhere. Among the small portion who do report, national data shows that only about 36% result in charges and only 22% ever make it to court. Only about 5% of all sexual assaults will result in a custodial sentence. So the system captures and processes a very small fraction of cases, and it's often the kinds of cases that involve weapons or visible injury or extreme violence, which are the least common types of sexual assaults. The reality is that most sexual assaults are committed by someone the survivor knows, a partner, a family member, a coworker, a friend, a classmate, and they often involve coercion, manipulation, an abuse of trust, intoxication, usually not weapons or extreme violence. So these are precisely the cases least likely to result in anything meaningful from the criminal legal system. These are the cases in which survivors may most want a process focused on truth-telling, accountability, safety planning, and the repair of ongoing relational and community harm. When I was 19, I reported to the police. My case was representative of the majority of cases that we see in Ontario and nationwide, which is two competing narratives with no sober eyewitnesses. The reporting itself was traumatic, but I was lucky to be someone who felt like I had at least been believed by the detective that I was talking to. The detective at the time was very explicit with his opinion that I should not engage with an investigation for my own well-being. And for a while, I thought that that was him not wanting to deal with me and wanting me to get out the door. But I've often wondered if that wasn't an act of mercy, because I didn't know any of this at age 19. Regardless, I had no path forward from that. It was a dead end. And there was nothing for me, any social system, nothing, no avenues towards even healing, let alone justice. The ambivalence of society to a horrendous violation caused as much trauma to me as the assault itself. The criminal system doesn't serve our needs because it's not designed to. It's not about us. It's not even about what has happened to us and the impact that that's had on us. And it's certainly not about justice for us. And that's not even to talk down on the system. That's literally just the facts of the system. It's about the crown. The experience is dehumanizing, not because of individual actors necessarily, but because of the structure. We're not parties in our own cases. The crown is the wronged party. There's no legal representation just for us. The sole obligation is not to us. So when D4 forces survivors into the system as its only option, even when many of us know that it cannot meet our needs, the result of this policy undermines autonomy, but also limits access to what might be meaningful for us. And a more just framework would start from a basic premise that survivor choice isn't in conflict with public interest. It's actually an embedded part of it. A just policy would trust survivors to decide what justice and accountability looks like in our own lives. And it would acknowledge that the system rarely provides anything that we need. Telling survivors that the criminal system is our sole route to justice just rings hollow. Yeah.
Thank you, Laura. Robin.
Laura, I'm just going to respond to something that you said. I just want to really thank you for your comments and say hello to everyone and how happy I am to be here with this incredible group. And just go totally off my script and just tell you about when I was an articling student. And I was on the escalator at 361 University in the Superior Court with a bunch of police officers and my articling principal, and we were going into some big important trial. And I don't remember what. And I was talking to the police officers about how if I was ever sexually assaulted, I wouldn't report it to the police. And they got very upset with me. They got angry at me. And I remember just being kind of baffled at their response at the time. And I'm just thinking about that investigator who said that to you, and how in Judith Herman's books, she talks about what is one of the most harmful responses a trauma survivor can have to trauma, and that is indifference or obliviousness or non-action. It's worse than disbelief, because disbelief we can respond to by feeling a sense of injustice. It activates us in an action-oriented way. But sort of non-action indicates that what's happened to us is unimportant. And, it just makes me feel really, I'm glad that that investigator said that to you, and also sad at the same time for that reason. I think to flip back into being a lawyer for a moment as the token practicing lawyer on this panel of esteemed people, I just want to say that I think part of the issue with the Ontario policy from a survivor's perspective, but just from a restorative justice perspective, is that it equates RJ programs with diversion. And that's an error that I think reflects a misunderstanding of what RJ is. And I hope that after today, you'll know more about it. In my experience, RJ is a more comprehensive approach than a criminal trial. And done properly, I believe that it reduces the harm caused by sexual violence, in contrast to the criminal process, which exacerbates harm and seems to have no discernible impact on the rates of sexual violence. And I say that because I've seen it both, having experienced a restorative justice process myself, having helped other people go through it, both as counsel and as someone delivering it in my role on the advisory circle of a restorative justice organization, and also because it's already happening. It's happening here in Ontario under the Youth Criminal Justice Act. It's happening in adult cases where Crowns can cleverly find ways around it. And it's being delivered successfully in other provinces, Alberta, and across the world. It's not perfect, but either is the criminal trial process. And so let's remember that. The person who caused harm is held accountable in ways that I've rarely seen in 30 years in criminal courts. And the person who is harmed is listened to in ways that they never are in the trial. And the impact of this on complainants cannot be overstated. Giving evidence and saying what happened to you are not the same thing. And in fact, some of the greatest predictors of recovery from trauma are being listened to and being believed in a community of care. And what this means when we think about that, and I would never try to tell any of my complainant clients or anybody that you should go through the criminal justice system as part of your healing. What in fact I say is that's something you need to put on pause until it's over. But when we think about what that means, what I just said, that the biggest predictors of healing are being listened to, being affirmed in a community of care, it means that the criminal justice system itself impairs recovery. I'm just going to shorten my notes a bit because I went off script, but I think one of the issues in terms of the policy is that the prosecutor is only required to take into account the circumstances of the offense and the offender. And what we need is for prosecutors to take into account the victim. The victim is no place in that right now. I'm not suggesting that victims should become parties to the criminal justice process, but what I am saying is in that assessment of harm to society, the victim needs to be placed in her social context. And what that social context is an epidemic of gender-based violence in which 30 years of criminal justice reforms, 276, 278, elimination of prelims, have had no discernible impact on rates of reporting, on rates of sexual violence, of rates of sexual harm, and on if you measure success by convictions, and I don't, but if you do, and on convictions. And if you put the victim in that context, we can then start assessing what society needs and whether looking for alternatives is useful. I think others are going to talk about the need for proper resource and funding, so I just want to end with this. In 2022, Jacob Hogard was convicted of sexually assaulting Jessica Baker, and he was sentenced to 5 years in jail. So we might say, if that's how you count success, that that was a success. I had the privilege this year of helping Jessica get her publication ban lifted, so the CBC could air a documentary about her called Breaking Idol. You can watch it on CBC Gem, and I urge you to do so, because this is when Jessica reclaims her voice. The first half of the doc is mostly about the band, but around 30 minutes, she starts talking about the criminal trial. She describes her cross-examination as the worst thing that's ever happened to her, worse than the sexual assault. And if you know anything about the details of the allegations, which were very bad, you can understand what that means. And she says that she has still not recovered from the trial. And if that is a success, I say we can do better. And Leaf, in their report, and here today, we're trying to show a different way where autonomy is returned and there's a place made for survivor voices in determining what's best for society. Thanks, Kate.
Thanks, Robin. I appreciate you and Laura doing such a really articulate job of dispelling the myth that survivors are looking for more convictions out of this process, and that's the complaint. Well, certainly that does exist, that you've articulated so clearly that survivors are looking for healing and justice, and we can't make assumptions about what that healing and justice is for survivors. We need to ask, listen, and respond to that. So thank you both. The next question. Though the concept of restorative justice and transformative justice may be new to many, communities that have been marginalized, over-criminalized, like Black and Indigenous communities, advocating for and facilitating restorative and transformative justice processes for a long time. So my question is, what kinds of safeguards and systemic forces do we need to address in order to ensure that restorative justice and transformative justice processes can reach their full potential? And I'll invite Rakesh and Audrey to respond to this question.
Audrey, did you want to go first?
Sorry, looking for the unmute button. Yeah, I wasn't sure who was going to go first, but thank you so much for inviting me today. Thanks to everyone for coming. I was very moved by both Robin and Laura's words. Indifference is that resonated so much with me because as the co-founder of No More Silence, we called ourselves No More Silence because what we would continuously hear from families of missing and murdered Indigenous women, girls, trans and two-spirit people is that their grief was so compounded by societal indifference and impunity. And so one of the big conundrums that as a group, a grassroots group that is really about decolonization and does not and is abolitionist, rejects carceral punishment, is that unfortunately for a lot of people in our community, justice is equated with punishment because it's different than indifference and nothing happening. So that's been something that we've really wanted to sort of grapple with. And we spent some time during the pandemic having conversations about decolonizing justice as it relates to missing and murdered, which is, you know, a really difficult subject. Just 2 days ago, I'm feeling the reverberations and being reminded of these conversations as in Six Nations, family of Joyce Green learned that her murderer would pretty much be released soon, got 5 years and would be released on time served. Of course, that family doesn't feel like their daughter, their mother. She was a mother of 5 children. She would have been safe in a shelter, but for some restrictive policies that ended up having her removed and left vulnerable and alone. Like, there's blood on so many people's hands in this case, and I think that was one of the central things that came out in our conversations, and that is different from what happens in the legal system, is that Indigenous justice looks at the harm in the context of the whole community. So it's not just looking at the perpetrator and the survivor, but what was everybody, what was the, you know, where was the perpetrator's family? What is their background? It's much more holistic, and it's a lot about restoring balance and restitution. So Indigenous women, for me, it's something that I've been thinking about for over almost, like, I think it was 25 years ago. I was on the Fraser River Journey for Justice in BC, where we were looking at the implications of restorative justice for Aboriginal women survivors of violence and their children. There's an amazing report co-authored by Anna Stewart, Wendy Stewart was the name at the time, on the report that you can Google and look for, that looks at the communities where we did focus groups. We went through 9 communities along the Fraser River because we were very concerned at the time. So Indigenous women haven't always been advocates of restorative justice, not when it isn't survivor directed and led, and when it can put survivors in harm, as we felt was the case. Because the irony was that it was being branded as something Indigenous, but it was being led by an Indian Act system that is a colonizer system and patriarchal to the core, and that replicates, gender discrimination. So just that contradiction in itself made it very difficult for the group that was doing this research, the Aboriginal Women's Action Network, to support that, while at the same time the community experiences mass incarceration and understands that carceral punishment doesn't work. So we very much welcome RJ processes that do center the survivor and that do, that don't put them in harm's way, like the legal system unfortunately does. And I'll pass it to Rakesh, please.
Thanks, Audrey. I'm so grateful to be in this space and learning from the brilliant panelists and folks like Roselle. Kate has incredible expertise. Mandy, Jessica, we're super lucky to be in the presence of so many folks with experience that we can really learn from. So I think governments should recognize that Black, Indigenous, and other racialized communities may have differential justice needs. And as Audrey has mentioned, and in the absence of adequate government programming, individuals in our communities have long cultivated their own approaches to conflict resolution and accountability. And so these models should be acknowledged and supported and resourced rather than rendered invisible. And that being said, I have a bit of a bone to pick with the Ontario Court of Appeal, because in a case called Morris in 2021, the court stated that, in contrast to several Indigenous communities, that for Black communities, there's no basis to conclude, quote, there's no basis to conclude that Black offenders or Black communities share a fundamentally different view of justice or what constitutes a just sentence in any given situation. And while I would agree with the court that alternative justice mechanisms in Black communities are often distinct from that of Indigenous communities, I would disagree with the implication that Black communities simply mirror dominant justice approaches. And that assumption actually erases the long-standing, culturally grounded alternative justice practices that already exist within Black communities. So, for example, despite the imposition of European legal structures, many African societies, including the Kapila tribe in Liberia, communities in Nigeria, and groups in South Africa, have maintained their indigenous justice models rooted in communal values and spiritual harmony. For example, in Liberia, the Kapela tribe relies on elders to mediate and arbitrate disputes between parties. And the primary goal of these processes is to restore the relationship between the parties and obtain spiritual harmony in the community. And Indigenous people in South Africa developed a formal legal system based on the philosophy of Ubuntu, a communitarian value that is core to several Southern African traditions, including the Zulu, Tswana, and Venda cultures. And Ubuntu is translated to mean a person as a person through their relationships. And it emphasizes interconnectedness and collective care. And these Indigenous justice practices in different parts of the continent remain integral to many communities across the African continent and often operate alongside Western legal systems. In partnership with the Canadian Association of Black Lawyers, myself and Nana Yanful, we recently published a report that examines alternative justice mechanisms used in Black communities throughout Canada, the US, and throughout the African continent. And through interviews with subject matter experts and community members, we learned that many Black people understand the criminal legal system through the lens of their disproportionate criminalization and surveillance, and the simultaneous lack of state investment in community well-being. So Black people are selectively included in penal processes, and this selective inclusion generates deep distrust of formal criminal legal institutions. For example, myself growing up in small town Alberta, I was told from a young age that our family doesn't call the police. When we have disputes within our family, we call friends, we call older people in our communities, we call elders in the family, and calling the police is a last resort. So from this distrust and from longstanding cultural traditions, Black communities have cultivated our own justice mechanisms. And Afrocentric worldviews rest on the belief that people are actually inherently good. They're embedded in community and they're capable of growth and transformation. These values don't necessarily map onto or align with punitive systems that remove individuals from their communities of care. So where state-run restorative justice programs do exist, Black folks are often excluded from them. Police and prosecutors refer Black defendants for diversion at lower rates, and RJ programs are underfunded and rarely equipped to deliver culturally relevant services. So Owusu, Bamfa, and Jones in their report for Canada's Black Justice Strategy, some folks may have reviewed it, it recommended mandating police services to increase their use of RJ diversion. There's actually a recently introduced bill, Bill C-16, it was introduced today, and it seems to introduce this measure by way of an amendment to sections 715.47 sub 1 for the lawyers in the room who might take a look, and also section 715.48, also sub 1 of the criminal code. So, but in my view, mandates alone are not sufficient. We have to also ensure that the restorative justice and transformative justice programs made available to Black and racialized defendants are culturally grounded, community governed, and properly resourced. So to answer your question, for RJ to reach its full potential, I do think that safeguards have to include equitable referral pathways, sustainable funding, cultural competency, protection from state co-optation, which is a big ask, and the recognition of Black and Indigenous community justice traditions as legitimate systems in their own right.
Thank you so much, Akash and Audrey. Listening to you speak, it reminds me, I'm often asked the question, well, where else is restorative justice happening? And the answer is like around the world, but squashed by colonization, making it less visible. And I think, Audrey, to your point of the role of community, in communities where we we have one another only, this is a way of being, of addressing harm and protecting one another that seems natural to communities internationally, and that colonization has just really invisibilized or taken that ability to do away. So thank you both for speaking to those pieces. Final question. What is one thing you want participants to take away from today's panel? And this question is open to everyone, but Rakesh, I'll start with you. Oh, just unmute.
Classic. That has to happen at least a couple times. Yeah, I think my work as a law professor is kind of to try to remind people that the law is deeply contingent and it's constructed, and we all participate in how it is constructed. So the criminal legal system is shaped by cultural norms and institutional priorities that shift over time based on our contributions in large part. So in my view, each of us, by learning and shifting and adapting and advocating, can help to direct how justice processes unfold. So I'd encourage folks to really engage in that and feel empowered to be part of this change that we're talking about today.
Awesome. Thank you. Audrey, same question to you. What is the one thing you want participants to take away from attending today?
There's that unmute. Yeah, for me, restorative justice doesn't go far enough. Like I think to end gender-based violence, we're going to need to end colonization and the settler colonial project. I know it's a long-term project goal, but I was very influenced by Angela Davis when I got to meet her back in 2000 Color of Violence conference in Santa Cruz, and she talked about you have to live as if we were in that place that we want to create. And that's what we're doing with No More Silence. We just opened the Hummingbird Healing Lodge, where our focus is on healing, on bringing survivors and families of those who don't in. But we have potential also to talk about those who, to welcome those who cause harm and to engage in their own healing processes. So that's, I think what's important is that we need to transform as a society, that it's not going to just be the legal system that affects the change that we really need to see happen.
Thanks, Audrey, and congratulations on the opening of the lodge. Robin, same question to you.
Just building on what Rakesh and Audrey have said, you can look at the legal system, like we're here today to talk about something very specific and small and narrow, which is Ontario's policy in respect of diversion in gender-based violence. But that situates itself inside the context of the legal system, inside the context of the society. And so just, going maybe out from the broad and into the specific, the justice system isn't out there like gravity or DNA, that we didn't sort of have to uncover it and study it to understand it. We created it through social interactions, through the social agreements that we make every time we walk into a courtroom and engage with a police officer, call the courthouse and speak to people at the courthouse and how they speak to us. And so for those people who are here today who work in the justice system in various ways, I want you to keep your faith and optimism that you can bring change simply by changing how you are inside that space. I recognize how incredibly idealistic that is. And it is an idealism that fueled my application to law school, to be a good person in a narrow, tight, uncomfortable, bad space, to try to bring light into that little tiny space. And it is a work that has a great cost to your heart. You experienced moral injury. It's hard work. But if in your dealings you can bring a restorative approach, in other words, if you can pause for a moment and remember that the person you are dealing with is a human being, everyone in the courtroom who's not a lawyer or a judge is having the worst day of their life where they talk about one of the very worst things that ever happened to them, whether they're the person who's been accused of causing harm or whether they're the person who's experienced harm. And for those of us who are information gatherers, the lawyers, the judges, the court clerks, they're giving us something called evidence. And in that process, we lose track of their humanness. And I actually believe that restorative justice and transformative justice is a call to recognize the humanity in others. And in some ways, this is a spiritual calling. It's a thing to say that is like nothing we ever say when we talk about the law. But if we want to bring that change, then we have to start making that change in ourselves and bring it out to others. And how I know that it's possible is that those of us in this group presenting to you today, and many of you who are here in the audience today, have been working on trying to bring more restorative justice processes into the criminal justice system for the last 10 years or longer. We've been talking about it, we've been meeting about it, we've been trying, we've been working around in tight spaces. And just this last week, the Attorney General of Ontario, or the week before, announced that they're doing a study of the very policy we're here talking about to look at whether or not it might be changed or be done differently. And that's not a coincidence. It's because we've been working on it. So let's keep working on it and being kind to complainants, to the accused, to everybody. In other words, like Audrey said, Angela Davis said, or like Gandhi said, just be the change. But just keep your optimism alive. I know that's a big ask. Never said anything like that at a law conference before, but there you go.
I appreciate that, Robin. And Laura, finally to you.
Thank you. There's a myth that we don't have the knowledge we need to transform our systems. The knowledge that we need exists already. When I began graduate studies over a decade ago, I was under the impression that everything was so bad because we hadn't properly explored it. And I was horrified to realize that there is a robust, multi-decade body of scholarship that very clearly lays out the root causes of sexual assault, how our adversarial state-based criminal system fails to deliver meaningful justice to victims of crime, and what needs to be changed. The research is here, and we do not read it. We don't interrogate it. We don't disseminate it. We don't integrate it. It sits in research databases behind a paywall, and we keep causing the same harm again and again. The data is robust. The data is incredibly clear. We must adapt and evolve. Our systems right now are based on outdated cultural norms and values, not on scientific data. We need to be less scared as a group of expanding our understandings and updating our systems accordingly. It's inconvenient to listen to this scholarship, but it doesn't mean that it's not vitally important for our futures.
Thank you all so much. I really appreciate everything that you shared and the care you put into sharing with this large audience the things that are important to you, the values, the ethics behind this work, as well as lived experience. I'm going to pass things over to my peer, Roselle, who will facilitate a question and answer period. We've got lots of time.
Thank you so much, everyone. That was such a rich discussion, and I'm really grateful for everyone sharing your perspectives and expertise. We've been keeping an eye on some of the questions, and I will ask some of them, and hopefully we'll have time to get through at least a couple of them. So there have been a few questions along this line, and we had some great questions about restorative justice and transformative justice for Black and disabled survivors. Can folks speak to some of the barriers marginalized survivors face? And I know Rikesh addressed this, started addressing this. And yeah, including those who are Black and disabled survivors, and the ways that we can ensure that the processes serve marginalized survivors.
Did you want me to take this one? I don't know if there are other folks who wanted to take this one.
Yeah, if you want to start, Rakesh.
Yeah, I mean, so there are some really great resources that I'll ask perhaps Roselle or any of the other hosts to share in the chat from folks who have been engaging, racialized, Black, disabled folks who have been engaging in transformative justice practices and processes for decades. And one of the ones that has really a strategy that's really stuck with me is pod mapping. I don't know if folks are familiar with that, but the practice of being intentional about identifying the people in your life who you trust with intimate mistakes you've made, intimate challenges you faced, and being intentional about building those trusting relationships so that in advance of harm taking place. So this is not a restorative justice process. This is a transformative justice strategy. And the idea there is to kind of be more precise about what we mean when we're talking about community, and be more intentional about building said community so that when bad things happen, we're humans, we are going to harm each other. I will cause harm, I will be harmed. But when I have communities of care, when I have a pod that I've identified, that I can reach out to when something happens, then perhaps we can do, as Angela Davis says, which is rendering the existing criminal legal processes obsolete, rendering prisons obsolete, because we have such strong community ties, because we have safety plans, because we have ways of being with each other to support each other and to hold each other accountable, and then to move through whatever formal processes we decide to engage in, whether that's through the criminal legal process or that's through an alternative justice mechanism.
Thanks so much. Anyone else would like to weigh in? Or move on? Okay. So another question I'll throw to the group is we've had maybe this is more for Mandy and Jess, but we had a couple of questions about Indigenous engagement, in particular engagement with the Northern Indigenous communities. And the question was whether we can speak to the research and recommendations to include Indigenous communities and any barriers and challenges that you encountered.
Sure, thank you. Happy to talk about research methods. So when I mentioned the limitations surrounding the North, that wasn't specific to Indigenous or First Nations communities. That was just a general statement. There was a lack of participation or challenges that we had with recruiting. So we recognize that as an overall limitation of the project. Our project wasn't intentionally recruiting specific First Nations or Indigenous communities specifically. With that being said, we did have quite a few participants who self-identified as Indigenous, were working in Indigenous organizations or organizations that served Indigenous populations, and as well as the participants themselves. So we did have quite a bit of Indigenous folks participate in the research, but we were never intentional in specifically engaging First Nation or Indigenous communities specifically, and that kind of ties into our recommendation around Indigenous legal sovereignty and revitalization. I don't think it would be our place to make those recommendations, but rather, as Rakesh was talking about, empowering communities and how nations define themselves to decide what justice is. So that was kind of one limitation of our work, but wasn't the exclusion of Indigenous people, because we did have quite a few from urban and more rural communities, just fewer from the north that participated. In terms of, I think there was a second part to that question, which was around the barriers and challenges and like resource constraints, I saw was in the question in relation to that as well. And that was something that we heard quite a bit about, specifically from folks from marginalized communities, whether that be sex workers, Indigenous peoples, folks who are racialized, in that how can we even think about restorative or transformative justice when our basic needs aren't even being met on the day-to-day. So that was a very, very real and tangible challenge of like, how can we even think about justice when I don't have because we talked primarily to service providers who are struggling to find shelter for women fleeing violence, for example. And I just wanted to share one other piece that we heard and I thought was pretty neat. And we did a focus group at a women's shelter, and we explained restorative and transformative justice. And several of the women actually said, oh, you know, I actually did a restorative justice process in wherever. I just want to maintain anonymity, but their home country. You know, I engaged in that process. It was led by elders. I would have never called it restorative justice. And so it was kind of neat to be doing this and meeting with survivors who had engaged in these processes, but don't have the language of restorative justice and an overarching desire for systems that don't force them into reporting to police if that's not the avenue that they wish to take. So with that being said, overall, we saw so much support for restorative justice, but the concern around resource constraints or potential for pressures to engage in restorative justice from community as well was a very, very real concern. And that was a lot of information to a very simple question around recruitment, but I wanted to touch on some of the other things that I saw in the chat. And is explored a bit more extensively in the initial report that I wrote with Tamara Burnett and is published on the LEAF website called Avenues to Justice, if folks are interested in reading a bit more about those more social factors that may contribute to ability to participate.
Thanks so much. I don't know if Jess, you wanted to add anything, or I could move on, or other folks too.
I mean, Mandy did a great job of kind of responding to that. I'll just echo, you know, we spoke to a number of folks that raised concerns around resource constraints, you know, in terms of implementing RJ. We're talking about, you know, what does this look like in a small rural space where everyone knows everyone, and these kinds of pieces. And so again, I think this is why we have, you know, recommended not only community consultation, but again, 3 to 4 pilot projects, which would ideally kind of be piloted in these different kinds of areas, right? Like, what does it look like to have an RJ pilot project in a rural area with significant resource constraints? And what are some of the challenges going to be? So we don't have the solutions to that, but those were conversations that were had in the context of doing these interviews, doing the focus groups, et cetera. And that plays into the specific recommendations we made.
So much. A question, I think, for folks who have participated or facilitated the processes, or this question is, what happens if a survivor wants restorative justice, but the person who harmed them refuses to participate? What expected restitution can be found through restorative justice?
Yeah, I could maybe speak to that. So a number of things could happen. So if the person who harmed them doesn't want to participate at community justice initiatives, they could have the opportunity to speak with a surrogate offender, someone else who's caused sexual harm, who's come a long way in their accountability. And part of their accountability is to community and giving back to community. And so supporting survivors with their justice needs where other people aren't doing that work. And so the survivor in this case would, you know, if they're goals were to be able to tell someone who caused sexual harm how they were impacted, or to ask questions of a person who caused harm, like what were you thinking at the time? What did you think about since? What does your commitment to not harm anybody else look like? They could have that experience. And there is a lot of research, like Alyssa Ackerman has done, to show that there's really significant healing impacts from these surrogate dialogues. And it also might be then that we talk with the survivor about, well, what else? So we always say, what does healing and justice look like for you? And it could be the case, and then we can't meet their need. If healing and justice for them looks like having a direct dialogue with the person who harmed them, and that person can't participate, then we wouldn't move forward. If they didn't want to surrogate a case, then we would explore other options of what would be meaningful for them.
You know if others wanted to weigh in.
Actually just put a reference to Alyssa Ackerman and Jill Levinson's book in the chat in case people are interested in that.
Thanks. I guess a little bit related, I just saw a question come in about like, how can restorative justice manage power imbalances for victims? And I don't know if Kate, you wanted to sort of.
Sure, I just need to hear that question again. I didn't quite understand it.
I think just addressing power imbalances that might exist between the person who harmed and the person who was harmed.
Yeah, power matters in these spaces. We know that when power is unattended to, that it can replicate harm, that these spaces can be misused to humiliate survivors, and all sorts of things that are extremely unhelpful and traumatic. And so we have to attend to power. And power can be fluid as well. So I think, in the fluidity of power, what I sometimes see is we will support cases where the person who's caused harm has been incarcerated and has lost most of their family support, lost their opportunity to be employed, struggles with stable housing, and the survivor's gone to counseling. Counselors done fantastic work. They're feeling more empowered. They have support in their life. And if they choose dialogue, they're coming to that conversation dialogue with power looking much, much different than it did at the time of the harm. Now, that's not always the case. Sometimes the power is unbalanced in a way that could still be harmful for a survivor. And so in that, we're working with the survivor to see how we balance that. Does that mean having more people in the room that believe them? Is that what that means? Does it mean that they have more decision-making power over how the process unfolds, where it happens, what questions are on the table, what questions are off the table? So we can work with power in those ways. And of course, we always need to be connecting interpersonal harm with systemic connections to what reinforces harm in our community and naming those connections. And so those are the ways that come to mind immediately for how we address power.
Thanks so much. And that was really helpful because I think, we often talk about these things in the abstracts, and I think there's a lot of curiosity in the room about what it actually looks like in practice. There was one question that said, the person said they're curious about how we can work to undo the social norms becoming more normalized for some of us that encourage thinking about people in binaries. The idea that if someone causes sexual harm, the only right response is to exile and condemn.
I might speak to that really briefly. And I think what we have to start thinking about is the statistics on sexual violence, how incredibly pervasive it is, and what that means on a really practical, granular level for your own personal relationships with people. So if you think about what the statistics are for sexual harm and who reports when surveys are done that they've experienced sexual harm, not report to the police. And then if you think about that someone is harming those people, what that means is that you know someone in your own social circle, more than one person, who someone else thinks has caused them sexual harm. That person who has caused sexual harm may not be aware in their own mind. It may not have even dawned on them that what they did had harmed this other person, because that may have never been communicated. So I don't want to, really overgeneralize, and it's really hard to address this, but I just want to start off with that basic premise, is that we are, in our daily interactions, there are people who are known to us who've experienced sexual harm, your family members, your friends, the judge, the defense counsel, your doctor, her daughter, right? And there are people around us who are accused of it. This is not a tale of monsters, to slightly misquote Adrienne Marie Brown. And so once we start understanding that it's completely embedded in our society, and we drop that dualistic idea, right, then we start understanding that the responsibility for it lies with all of us, right? And so when I first started having conversations when I first became a defense counsel and started defending people charged with sexual violence cases, people would always say, how can you do that as a feminist and you're not a real feminist? And I would always say, well, what if your son, your brother, your grandfather, your husband was accused of causing sexual harm? And the person would usually say something along the lines of, you look, oh, you annoying defense lawyers, you always make reference to the innocent accused. And I always replied saying, I never said that they were innocent, right? And that's what we have to address. And that's really, really hard to do, because it's a horror that lives among us that we would rather not look at. But as long as we can keep people's humanity in mind, then we can live with those contradictions. I don't know if that helps, but I think it's a truth.
Thank you, Robin. Jess, did you?
Yeah, I just wanted to jump in from a perspective that I'm more familiar with. A lot of my research is around prisons and working with folks that are incarcerated. And I think it's useful to also keep in mind that, the vast majority of people who cause harm and people that are incarcerated have themselves been victimized pretty substantively. And so part of the way I think of breaking down this binary is understanding harm as the result of unmet needs. And if we can kind of intervene in that cycle to meet the needs of people who are harmed, we might be able to prevent kind of further harm from happening as well. And that involves also meeting the needs of people who are causing harm, who have previously been harmed, but often had that harm unacknowledged, unaddressed, and so on and so forth. And so, again, I think this binary between people who cause harm and people who have been harmed, this ignores the fact that those who are causing harm have also often been subjected to substantive harms.
But I just want to add to that also, though, it's really important. It's not the person who's been harmed's job to do any of that, right? And I know that Jessica also thinks that, and I just want to be really clear to the people, because we can't see your faces, that that's not what we're saying. That the person who's caused harm, even though we're advocating for people who want restorative justice to be able to have it, we're not saying that that's anybody's responsibility, but the person who caused harm to take responsibility for their own actions. And that core is very, very different from what happens inside a carceral process also. So
I might just add a thought to that, and that is, with the stigmatization that occurs with people accused of a sexual offense in a criminal legal context, but social context too, to be found guilty of a criminal offense around sexual harm and to be incarcerated with those charges and to live the rest of your life with those charges, it is no surprise that through the criminal legal process, people run away from taking responsibility for that harm and minimize, deny, blame, which all has devastating consequences for the person they harmed. In restorative process, we can engage meaningful accountability because it keeps people's dignity and humanity intact. They can take responsibility for that harm that they've caused while still their humanness having space in that process. And so when survivors say, I want meaningful accountability, restorative and transformative processes do that really well. I mean, to the extent the person is able and willing, of course, we work with people who aren't able or willing to do that work, and so we can't move forward. But I have to tell you, at CJI, I continue to just be amazed by people who are willing to take that journey. They want to repair, and if you've ever caused harm yourself, you know the peace it gives you to repair that harm that you've caused. And I'll stop there.
If I can also jump
yes.
in, to speak truly from the heart on this, not every survivor needs to become an advocate and an activist and a researcher. That is not. But that was a route for me to understand what had happened to me and why, and to be able to contextualize it and understand it. And that journey really led me to seeing beyond my individual experience, which I think is something that I would really, in talking about how do we interrupt the binary thinking of, people who do harm need to be punished for it. What happened to me was not solely the result of one person making a bad decision that I became collateral damage in. It exists in a much, much wider cultural and social framework than that. And it's a bit of a cop-out to view sexual violence or interpersonal violence of any kind as these individual acts. Because we can see through statistics that sexual harm is one of the only violent crimes that is not decreasing over time. Sexual violence is an embedded part of our cultural and societal experience. It's not a singular bad apple who goes out and decides to cause harm. It is embedded in so many ways. Violence in general is embedded in so many ways, and sexual violence in particular is a cultural norm that is long-standing and has a very, very robust historical context. And so for me to think of accountability being only the person who harmed me, that's how we keep not taking accountability as a community for this kind of harm. If we can place blame on individuals, we actually will never see an end to sexual violence, because it is not only the individuals, it is the entire framework that props that up. It's all of the pieces that are connected. And so the individual needs are so important. But moving beyond and seeing the greater landscape of how deep of a problem this is, the individual punishment will never be the end of this type of violence. It has to be all of society actually taking a really good look in the mirror. And what are all of the ways in which we reinforce violence and domination as the best thing that we should all be doing? Because that is truly what the framework of our colonial, patriarchal society is. It is all violence and domination, and the state just doubles down on that. The state has the biggest stick, and so they get to make the rules. That kind of framework of society will never have a world without violence, because everything about our world is embedded in violence. And I think that kind of understanding is really necessary for moving beyond this thought of an individual acts a certain way and therefore we have to respond in a certain way, because we are social beings and we exist in a complex matrix of relationships. And to not view it that way is a bit of choosing ignorance and not wanting to be a part of the conversation. But we actually all need to be a part of the conversation in order for this reality that sexual violence is a very, very common, normalized thing. In order for that to go away, we all need to get into the mess together and work on teasing it out.
Thank you so much. We're almost out of time. I just wanted to, I guess there was one question about an upcoming Supreme Court case called COPE, which the court will hear later this week. If it goes well, then there is a potential for this decision to give more weight to Indigenous-led justice processes. So yeah, I think, did Audrey have her hand up? Oh, okay. Anyway, so I don't know if there are any thoughts or if folks have been following this case.
I'm not familiar with this case, so I'm out on that one.
And the case to watch, I think, yeah, it's a case where two people, both parties involved were Indigenous, and really the question was, the circle had recommended less incarceration, but the sentencing judge disagreed or did not take that into the sentence, saying that the public safety threat was too high. And so I think there's a lot of things to explore there about, yeah, incarceration and accountability, how much weight to give to sentencing circles. So that case will be heard Thursday, Friday. I know that we are at 6 o'clock, so I think I just want to thank everyone for, yeah, I want to thank the panelists for all of your insights, your time, your passion, your generosity in sharing your experience and expertise with us. I want to thank everyone who stuck around until now and asked us questions, left us comments. Really appreciate everyone's engagement. And what I take away from today is that we really need to repair the harm, which is what restorative justice focuses on. We need to get us out of the indifference that we are often forced to feel, or that the society makes us say that's normal. And for a just society, we also need to prevent future harm, and that prevention requires systemic change. We focus a lot on restorative justice, but I think this is where transformative justice comes in when we talk about creating a more just system. One small action you can take today is a letter writing campaign to the Ontario government to adopt the recommendations from the report, especially to amend Crown Policy D4. That will only take a couple of minutes. I will share a link to that. And if you found this webinar helpful, please consider supporting our work, both at Community Justice Initiatives and LEAF. We'll share links to our organization as well. And on behalf of everyone on this panel, I wanted to thank everyone for being here. I hope everybody has a good evening. Take care.